competition. Indeed, it was a learning process for me also to learn from the students. Now, the law which we saw, the law of education which we saw, it was in 70s. It was treated as a last resort, particularly students who could not get any seat anywhere. In fact, that also happened to me because I could not get set for MSc, so I joined law. I don't know how I finished 3 years course law. I got an opportunity to go to Mumbai for 6 months, but that gave me a lot of inspiration in the law practice. I shifted to Bangalore and I joined the council, senior council, then designated who came from Mumbai and one of the giant of the Karnataka bar. We had a traditional practice. I don't want to go into my particulars. It was a traditional practice because what we learned in the law colleges was the basic laws. And I still remember the Moot competition was not between the colleges. It was in the classroom we conducted the Moot college, but I did not understand the court procedure also till I entered the court. Now, what is the importance? What is the changing? Now today you have a phenomenal change in the law education. Law course, law practice, everything has changed. And particularly I may say so in recent 5 to 10 years, there is a tremendous change. Because I conduct the classes for the judicial office, newly recruited judicial officers, youngsters coming to the judicial services also. The quality of education is changed. The nature of learning law is changed, completely changed. What was ignored earlier, he has become the one of the most aspirant sought for. And I had occasion to go to many of the universities. And I found the students also well equipped. And today it is not that easy to practice. After AI has come, it is not that easy. And I'm not a techno side. I was not knowing. But for some information when I contacted and I just opened the Gemini and other things. What a technological development. What is the changing dimension today's profession? How you can equip with the current requirement. We have the litigation side, we have the corporate law, we have the judicial side, we have other than the judicial side also. Law graduates are smart, but must be competent. Those who are competent, they have everything in the law. But the competence comes not because you have conducted a moot court competition, and I was fortunate to hear the final contestants. So the preparation is concerned. Maybe at the stage of learning, if you are conducting a moot court, which is one of the important, and Chancellor may agree with me because he is a great academician and all of them are great academicians here. Today every profession requires a skill lab. There is a requirement of skill development at the college level because you will be entering professional career where nobody will teach you, but you have to gain yourself. I'll tell you in my experience and how you should be as a junior or you should be part of the law firm. Unless show your ability in the law firm or with the senior, you will not be recognized. Recognition is not how many cases you conduct, how best you conducted, how best you perform in the court, that's more important. Now coming to the changing dimension of law, because of all of the academicians are on these dais, they know today's trend. Today requirement, because I conducted arbitration. Many youngsters come before me, many seniors come, how they assist. And the young ladies, particularly lady advocates, how they assist the senior. One case I remember that they are with 3 lady advocates assisting the senior, one of the biggest arbitration case. And all they were with today's, nobody will move without the laptop and the what is that called, iPad. They were all ready. Whatever the question, even before we could whisper, they will be ready with the answer. One is after another, one after another, decisions and particular paragraph, particular sentence. So this is the preparation. And then I asked, how long you work? They said, we have no time. That's most important. I still remember when I was a junior. My senior started practicing in 1933. He moved from official court to district court to Bombay High Court to Bangalore to Delhi. So on. When he was post 17, maybe 78, 79, when I joined. He used to come to office around 7:30 to 8. And from 5:30 we used to be in the office. That time there was no computer or search or research or anything. Everything physically used to do it. There was ready referencer, there was a citation referencer. Like a computer, we used to search for that one after another. And at 7:30 used to come and start discussing the cases. Used to be 10:30. But only after 10:30 used to ask me what is the time. Sir, it is 10:30. All right, we'll wind up quick. That means another half an hour. And those time in 80s, 11 o'clock you never imagine of any bus, anything. Most of the time I walked. And 11 o'clock, what food you will get? Only non-vegetarian hotel somewhere here and there, they used to be there. So you have to knock their door and also get, if you get lucky, you will get it. That was necessary for me. That became, see, that difficulty, he knew that I am facing a difficulty, but he wanted to see that you face a difficulty. Unless you learn, you will not. If you are easily get everything, then you will not understand. So the preparation is concerned for the juniors is concerned, very, very important. How you can prepare. Today I was hearing the cases. I just want to put a question, because at this stage you will be going for so many decisions referenced in the books and the memorial and other things. But every judgment will not be applicable. What judgment you are referring must be in the context of that judgment and the context of this case you must analyze. Analytic manner is very, very important for a lawyer, for a minister. You always question whether it is correct. Even if it is correct, you have to question. And today's world, in the AI world, yesterday I had one issue with regard to the environment issue. So I just asked the AI. It could go around 150 files. It could go around 150 files to search your complete answer and give it to me. If the AI can do 150 files, turn out in a short time, what would be your requirement? As an assisting lawyer, what would be your requirement? You can't depend on AI. You can refer to AI, but don't depend on AI. Depending on AI, because natural talent is different from artificial talent. You have a natural talent, but if you totally succumb to the AI, you will never learn. You will become addicted to the AI and you will not get your natural talent. And you will always feel that AI is correct. And most of the time AI is wrong. Unless you verify, correct it and file. So data-based assistance is more important now. Now there is a predictive analysis also. I do not know, most of the teachers and chancellors must be knowing it. Predictive analysis is something which you give a problem, like a case law, whatever you give a facts and feed it. Predictive answer is the judgment which is given by the AI. If the judgment is coming, you will be knowing what judgment is. The party who is interesting case is much ahead of you. Today's corporate world, they are much ahead. They want a competent lawyer. They don't want the AI lawyer. So the competency is, that is why I have mentioned, casually I mentioned, you are citing a judgment, but you must know under what context the law is laid down and whether it is applicable. So reading is very important. Everything, cross verification is very important. The law education is very, very, very important. And moot court is the one step in the profession. Is the first step in the profession. What you will see in the moot court? Moot court you will see, first thing is your dress culture. Second thing is how you stand. Third thing is how you present your case. Third thing is how you analyze these facts. Fourth thing is how the issue is framed. Then how to articulate your argument so as to it must convince the judge. The convincing judge is not that referring to the judgment. On facts it must convince the judge, then go for the judgment to say that this is supported by a judgment. Not the judgment will support to the facts. Never say that. This is the, today I saw it, the judgment was there, judgment, this is the judgment, this is the judgment. This is not the judgments. That is the fact of case which is to be decided, not the judgment is to be decided. So you need to learn that first you must be mastery of facts. You must be mastery of fact, then you can see. That is the most important thing is you must be expert in substantive law, you must be expert in evidence law, you must be expert in procedure law. If you are really want to be on the litigation side. And my personal impression, subject to others whatever may say, litigation is the real profession than any other corporate law or any other thing. You will have an opportunity, you will get good some money, but litigation you really enjoy. And it is like an intoxication. In fact, it was an intoxication for me. I was reluctant to leave the profession. And even if I am asked, I go to the Supreme Court even now also. If asked to argue before a municipal, I can argue. But I am barred to argue, that's a different matter. But it's a litigation, gives you so enthusiastic, it gives inspiration. One case if you study properly, that itself motivates you to go for the others. So, first thing you learn as a junior, this is all just my personal experience and my experience I am just sharing with you, that if you join a corporate law or a individual law firm, whatever it may be, see that you be punctual. Before your senior, before what time you should be there, you should be there. The senior must feel that your assistant is assistant. It is not just going there, sitting there, taking some file and reading and going with him and giving books. He must feel assistant means you must be ahead of him. You must be ahead of him means your preparation is much, because you will be going. If you start going after your senior and before senior leaves, you leave the office, you will not get anything. But the brief which you are going to assist, you must be thoroughly prepared. How do you prepare yourself? In a given case, one case, how do you prepare yourself? You must understand the facts. You must understand the other side's case. Then you must understand what law is involved in this. And the law must be read properly. Every provision must be read not once, it must be read many times, so that you can understand correct meaning and correct interpretation. Every time you read, you may get different interpretation. So what interpretation you want to convince the judge, you must make out that. And when you are on facts, if you apply the law, then you open the judgment, whichever judgment you have, you can show the judgment, this is supported by. But don't show the judgment, then read the facts. So this is first thing. And the preparation is done. Senior, these are the decisions. If you show him that these are the decisions and this is the point of law which I have done, he will definitely feel happy. Because there is a person who is the assistant. Most of the seniors are busy. They want it. Today in law firms, they have got a new chance. When one of my friends' son wanted to join a big firm, then I asked the firm that he wants to join. First thing he asked me was whether he wants to join the litigation side or non-litigation side. So there is a lot of demand. So the litigation side is accommodated. This is the position today. Today, what is happening is there is a specialization. I never knew that there is a law firm dealing with the sports law. I never knew a law firm dealing with the marine law. But today you have got different kinds of law firms, different kinds of expertise, different kinds of lawyers. So there is vast. And every firm, irrespective of whether it is a law firm or anything, any corporate body, any organization, including the educational institution, do have the law assistants. do have the law secretaries, and particularly now they are called as president, vice president, legal cells. Every establishment is having a legal cell because nothing moves in without the law. No organization, no the society, no law college, no corporate body. Everything has to go today. Now, new thing which I now I noticed is there is a very systematic the firms dealing with. It is the integrated firms. Integrated firms is not just the law. They have got the project work. Now the project management consultancy services, where there is a law, where there is an engineering section, where there is a land section, the revenue section, everything is integrated to give a complete solution for a project because a lot of investment come to India. Lot of people coming from outside. I had an occasion to deal with a Chinese firm in an arbitration matter. How they invested, how they contacted the Indian firm, how they interacted, who was the assisting. Land revenue, labor law, every law has to be studied because that investment which they are going to make must, including the market strategy, so many things. So this is integrated firms which will cater the need of those people which they don't want any litigation. One example must be knowing also. One of the retired fire judge from top court, who was an arbitrator in Singapore. Now AI, I am telling you about the AI. He passed an award, and that award was within 3 days it was set aside. The reason was they say that this is copy paste. These are all copy paste. Most of you read it also. So if it is a copy paste, it is very easy. AI will trace you that you are a copy paste. You are not applied your mind. This is not the practice. This will not help you at all. So taking the copy from the judgment paragraphs and pasting it and making an award is not. So there is it is not, and your language must be very clean. Language has you have to have a control on language. Court manners. I will tell you how the law firms, small incidents. A lawyer starts a chamber. The chamber where he sits, he has a timing. And perfect timing, 9 o'clock. And I have seen that one person starting office at 7 o'clock. And at 7 o'clock he is there in the office. It doesn't matter who is there or not. But people know that he is coming at 7 o'clock. If you give it 7 o'clock and come at 10 o'clock, nobody will come there. And his posture, even in the office, very systematic. He never sat ugly. He was well dressed. When a client briefs you, he must have a listening power. Unless you have a listening power, you can't assist him. And you have to learn to unlearn many things. Most of the time what we do is, before you could say, what you say, yes, I know that, yes, I know that. So you will jump to your conclusion that the fellow will feel that this man doesn't want to hear me. So the law practice is individual personality development is important. Your involvement when you are talking to the client is important, and you must be not involvement in listening only. You must be making notes. You must show that you are involved in this case. You must show that you have a lot of interest to help him. So time is important, dress code is important, and how do you present in the court? How do you appear? I have practiced, I have also seen the people practicing before me. How? You must be well dressed. Now, most of the leading lawyers, top leading lawyers who have made names in the country, including I had an occasion to hear the arguments of Nani Palkewal. In 1993, that is a leading case where they always go to the judge. If the judge, while arguing, if the judge asks something, immediately